Hi, my name is Vanessa Terzian. I'm a partner here at Lagerlof, and I focus on estate planning, trust administration, and probate. Today I'm going to talk about a couple myths about estate planning, some common misconceptions. One of the first one is that only the wealthy need a trust, and that's just really not true. Actually, here in California, if you have assets in real estate over $50,000, probate gets triggered, and which is a long, lengthy court process if you don't have a trust. The other common misconception is that a will avoids probate. And unfortunately, I like to think of a will like a ticket to court. It essentially initiates the probate process the family goes through, which takes about 18 to 24 months. So if I pass away with just a will, or of course nothing at all, my family goes through this probate process that is completely avoidable by actually having a family trust. The other reason we want to avoid probate is that the fees are very expensive. Probate is 4% the value of the gross estate. So if I have a $1 million home, my family pays $40,000 in probate fees. The easiest way to avoid probate if your estate exceeds these dollar limits is to set up a family trust with one of the attorneys here. It's important when you're setting up a family trust to realize the trust is like a big bucket. You lay out your wishes inside the terms of the trust, which says where you want your assets to go, who would be in charge, how things get distributed to your loved ones. But the most important thing about a trust is that it's administered privately outside of the court process. In order to ensure that the trust is successful in laying out your wishes, you want to make sure you discuss this carefully with your attorney so they understand your goals and objectives. Finally, the most important step that many people miss is that they don't fund the trust properly. So once you set up the trust, again, going back to the analogy of a trust like a bucket, you got to change title to assets. So that's why you'll see people with their homes in the name of the trust. They actually have to change title. That's something we work with our clients on to make sure we've checked off the list very carefully to retitle any real estate into the trust name, change bank accounts, investment accounts, life insurance, the trust can become the beneficiary. So it's very important to ensure that you're working carefully with your attorney to make sure all the assets are properly funded. Finally, once you set up a trust, you don't want to set it and forget it. It's something that you should come back to review about every 3 years or so. At those review meetings, we look at what the client's plan says from 3 years ago, and we compare it to what their current situation is. We look at who's listed in their key role players, not only in their trust, but as part of your estate plan, you'll have a medical directive and a power of attorney. If you have young children, you've taken a look at who's their guardian, and maybe that's changed over the past few years. And then going back to looking at your inventory of assets to make sure that, again, they're connected to the trust in some way, shape, or form, either through the beneficiary designation or the title. So an ongoing relationship with your estate planning attorney is essential to make sure the plan stays up to date as possible and life events haven't made the trust outdated. Feel free to give us a call if you have an existing trust and you're not sure that it's properly funded, or if you have just a will and you think you might need a trust, or again, if you're starting from scratch and you think you need some basic estate planning documents. We're here and happy to help. Thank you.